So, as previously introduced, I am Nohra. Thank you for the introduction. And I prepared this presentation with my colleague Maša Štampić, who is, I hope she is following online, because she has a back problem that did not allow her to assist in person in here. So, our discussion today will focus on the Maritime Labour Convention, which is one of the key legal pillars designed to quality shipping at sea. And despite the formal obligations outlined in the MLC, we find in practice a lot of cases that involve unpaid wages or insufficient food at sea or any denial of repatriation or medical support. So there is a kind of discrepancy between what is legally and should be and what is in practice. And this is what we are going to focus on. And the small maritime states that I will be speaking about are two, Montenegro and Malta. Now, my colleague Maša is from Montenegro, and this is why we have chosen this state to speak about their seafarers. And on the other hand, Malta, despite being one of the smallest country by land area, has succeeded in becoming one of a significant maritime state. Not working?
Not working.
No, it's not working. Anyways, so the outline of the presentation will be that I will go quickly on the MLC Global Framework and amendments. I will be speaking about the key features of this International Maritime Convention, and then I will speak about Montenegro as a state, or most highlighting their role as a labor supplying state. And then I will speak about Montenegrin seafarers beyond borders. And here I will speak about two real cases that my friend Maša had dealt with in person as a port state inspector and MSC focal point in Montenegro. Then I will speak about Malta as a leading maritime nation and what makes Malta that leading in this industry. And finally, I will conclude and recommend things that can be not only applied to Montenegro, but on to all other maritime states, small maritime states. Okay, I forgot about this. MSC 2006 Global Framework and Amendments. So the key features of the MSC is known as a Bill of Rights, and as a Bill of Rights, it stands on a same pattern as SOLAS Convention, Safety of Life at Sea, MARPOL Convention, and the STCW. And somehow, some of their key features are present also in the MSC. I should stress on that the MSC is not a self-executing convention, which means that after being adopted or signed or ratified, states need to implement this convention into their legal framework. So to give it a taste, a shape of their national laws, so they can appoint the maritime authority that is in charge in their legal regime, or yes. And here comes the substantial equivalence feature. The substantial equivalence is that the MLC had presented some standards that states, when they are implementing these international standards, should not go below them, but focus on rather either adopt them or strengthening them. Another key feature is here, the no more favorable treatment clause. And this one is really important, as it is a fourth pillar of quality shipping at sea that the IMO had introduced, IMO and ILO. The more favorable treatment means that each state should adopt the MSC as a standard for the inspections at port. So there is no more favorable treatment among the states that had adopted the convention and those who did not. The third one is the tacit acceptance of amendments. And in this one, it's designed to stay recent to the changes in the maritime sector. What I mean is that, for example, the COVID-19 exposed a lot of weaknesses in the MSC that to stop this big infringement of laws, the ILO had made suggested an amendment in 2021, and it came into force in 2022. But what is really special about this tacit acceptance of amendment is that states, if they do not have any objection on the amendment proposed by the ILO, in this case, this amendment will come into force without any objections, and which will guarantee a simplicity and a speed in the implementation and the ratification of the new amendments and that one. Now I will move on into Montenegro as a labor supplying state. So Montenegro is a small and traditional maritime country with over 7,000 active seafarers. The government of Montenegro has ratified the MSC in 2013, and Montenegro is also a member of the IMO and the ILO. But Montenegro lacks of a robust legal framework aligned with the MSC, which means that Montenegro's enforcement of this law is weak. This is why a lot of cases can happen in real life. The key issues include the lack of specialized inspectors and maritime experts at ports, no oversight of foreign recruitment agency, and I will stress on it, especially in the conclusion, no strong monitoring system for intermediaries, crew and manning agency, so placing Montenegrin seafarers abroad, along with a tiny ship registry and limited access to international support for abandoned seafarers. Now, my friend Maša would more expand on these points because she's in person included with the real cases of these issues. Now, Montenegrin seafarers beyond borders, and here is the core of this presentation, where I will be speaking about two real cases. The first one is the case of the Maltese flag My Axioma, in which Montenegrin seafarers submitted complaints directly to Maša. And the second one is the case of the Italian flagged MV Santa Cruz, where similarly, Montenegrin seafarer reached out to her assistance. And we shall start with My Axioma vessel. So the first issue is that there was a non-lawful termination of the employment agreement without proper notice. So in this case, Montenegrin seafarers were on the ship. Montenegrin seafarers was on during his annual leave, so in his home country. And during his annual leave, the ship owner has sent him a termination of contract. Now, nothing is wrong with terminating the contract within the annual leave, but the main issue was that there was no notice, proper notice of the termination of this contract. So 7 weeks, as it is mentioned in the MSC, or 14 weeks, which is mentioned in the contract of the seafarer, the seafarer's employment agreement. So this is the first issue. The second one is that the ship owner considered that this seafarer has already been repatriated to his country. So the ship owner had escaped of paying the fees of repatriation. And this was the main issue, because this seafarer had, on his own expenses, go back to the ship to receive his belonging and to take back his belongings and finalize the documentation. So in this case, the ship owner claimed that because the seafarer had already been repatriated, the ship owner is not, the seafarer is not entitled to repatriation costs. This situation constitutes a violation of Regulation 2.1 of the MSC, which mandates clear contractual terms and fair procedures for the termination of the contract. Furthermore, the 2022 amendment of the MSC explicitly clarifies the obligation of ship owners to follow proper termination procedures and to protect seafarers from sudden or unjustified dismissal. No recognition of ETO certificates. The ETO is a position on board the ship, and this Montenegrin seafarer was holding an ETO certification from the Montenegrin government. And in this case, the ship owner should have endorsed his ETO certificate from Montenegro within the Maltese registration, within the Maltese government, to be able to practice his functions at sea. So, in this case, there is a violation of the training and certification laws regulation mentioned in the MSC, along with the 2022 amendment that strengthen the requirements for flag state to verify and accept the certificates of foreign institutes. Thirdly, lack of social insurance coverage, and this was a shock because seafarers shall not exercise have the right actually to exercise their functions at sea, knowing that they are fully covered. However, in this case, the insurance was expired and the ship owner didn't bother to renew it. So in this case, the Maltese government didn't know about this specific issue, which should be between the ship owner's hands, and this is how it went. However, if the Maltese government had knew about this, there is two provisions of the Maltese implementation that guarantees first the right of the seafarer to have an insurance at sea, and secondly, to be provided by the ship owner. However, here there is a small distinction in the Maltese laws on this point, specific point, that says that if the Maltese seafarers should provide, the Maltese seafarers on board ships have automatically the security insurance, the national security insurance. However, the foreigners, ship owners should have applied to them to other insurance companies. Now, fourthly, unsanitary onboard conditions. And it's obvious that it's the responsibility of the ship owner to protect their seafarers and the environment of the living environment of the seafarer, which is on ship. So these seafarers were living with a Legionella bacteria that had been afterwards led to a lot of allergies and not well-being of the crew on board. Finally, the final point that I would like to speak about is that there was no access to onboard complaint mechanism and no cooperation by the master. And this is a right for every seafarer to speak about their the missing things that they have. And these missing things, as we see, like the sanitary at sea, the sanitary conditions at sea, as long as the right of having an insurance were dismissed in this case. So, however, penalties can be expected over the master of ships, the master of a ship, in case non-compliance within the this is within the Maltese law. However, we cannot speak about this provision of the law if it's not in front of any court. So the seafarer, there's barriers in front of the seafarer to have access to the right to this penalty over against the master of ship. Anyways, the second case that I would like to speak about is the Santa Cruz case. So this ship, okay, just to mention that we will be focusing on the facts of this case and not entering into the reasons why this happened, because our knowledge and our focus is on the rights of seafarers within this case. So this case was burst for a long time in Genoa, in Italy, and actually this ship was detained by port state authorities because the ship was not fulfilling the requirements to sail. All the crew stayed on board the ship, among them 5 Montenegrin seafarers. So, in this case, seafarers were trying, especially we're focusing on Montenegrin seafarers, were trying to reach out for help for them to be repatriated, to have their wages, or to be dismissed of their functions. However, they stayed on the ship because they have no other place to go. Now, I will focus on the first issue, which is the abandonment of Montenegrin seafarers in Genoa. So, in the MLC regulation 2.5.2, which speaks about the repatriation and the abandonment laws, the ship owner, the seafarer is considered to be abandoned in 3 cases. The first one, if the ship owner fails to cover the costs of taking the seafarer back home or to the place of choice in their agreement. The second one is the seafarer has been left without necessary maintenance and support. And the third one is the ship owner has cut contact with the seafarer and they have not been paid for more than 2 months. So if a seafarer has not been receiving wages for more than 2 months, this seafarer is considered to be abandoned. So in this case, if we combine the factual elements with the legal elements that I just said, we have that the ship owner had not paid these seafarers for more than 3 months, the time the detainment of the ship in Genoa. The second one, the failure to provide food and water and medication at sea. And here I want to stress and say that one of the seafarers nearly fainted because of the poor conditions and the lack of food and potable water at sea, not to mention the medication, and that the national state of the seafarer, which is Montenegro, had ordered an ambulance to transport this seafarer to a good place so that they may receive a good quality support in this condition. And the third failure is to repatriate seafarers on board. So this ship owner had abandoned clearly the Montenegrin seafarers and the other crew on board. The third one is that food, water, and medication was provided by NGO, who is Stella Maris, on a voluntary basis, knowing that food, water, and medication should be either in the case of the owners missing this, not doing this obligation, the flag state should support them, or the port state, which was lacking in this case. And at the end, the delayed response from institutions. So in this case, the seafarers were trying to reach out to the ITF or to any other international organization that could guarantee their rights. So, but at the end, the seafarers finally, after a long time and a lot of efforts, finally reached the P&I Club, which guaranteed their first payments, which they dedicated the payment of their wages at least. Now, I have some photos of empty food storage. These are actually, I did something. Okay. Okay, so these are actual photos that prove the situation on board this ship, and these were provided by the seafarers who were complaining to my colleague Maša about the situation. Montenegrin seafarers, I'm stressing on that. And this is how it went. Okay. What's happening?
Click now.
Okay, thank you. One more. Now I want to speak quickly about the Maltese flag. Okay. Okay, so Malta is a leading maritime nation, especially that most of their GDP comes from the maritime industry. So Malta the Maltese Ship Registry was founded in 1973. And Malta is the first merchant shipping fleet in Europe, according to the number of vessels, and the sixth merchant fleet in the world. So, how does Malta enforce the protection of seafarers' rights? And here, I am speaking about this comparative aspect to take the lessons for other maritime states, small maritime states, like Montenegro in this case. So first of all, they have a robust and efficient legal framework. And Malta has incorporated the MLC through a subsidiary legislation 234.51 entitled the Merchant Shipping Maritime Labour Convention Rule. which entered into force the same day as the entering into force of the Maritime Labor Convention 2006, which is in August 2013. Malta is highly committed to incorporating amendments into its law. So as soon as an amendment comes into force, its implementation is immediate and is actually ready to stay recent on the recent basis. Okay. And secondly, and which is most importantly, the effective inspections. So Transport Malta is the primary Maltese governmental authority responsible for all means of transport, including maritime transport. And they have many directorates. For example, the Merchant Shipping Directorate, which is a division within Transport Malta and conducts regular flag state inspection of Maltese registered ships worldwide. And in this matter, they have 64 inspectors in more than 45 countries. And we presume that these are big maritime countries where their ships mostly go to, in addition to statutory surveys by classification societies. Now, there is two things that I need to mention in the slide before moving to the second one. The first one is that the Merchant Shipping Directorate is divided into many departments, and each one focus on a special area, such as the technical performance, safety inspections, and international relations. For example, the technical department oversees the Malta Flag State Inspectorate, which conducts inspections of Maltese registered ships. And the second thing is that there is random inspections since 1993, which is a good thing. Now, the growth of Malta Ship Registry. In this chart, there is the number of registration of Maltese ships, in the Maltese registry. And what I would like to speak about is the period between 2019 and 2024, where around 3,000 vessels were deflagged from Malta. The Transport Malta has taken this decision because these ships were not sailing according to the Maltese standards or the international standards enforced by Malta, which is a good thing, because after this decline in 2022, the ship registry had registered more than 1,318 vessels, and these numbers are correct. Okay, according to April 2025. Okay, now we come into the conclusion and recommendations for small maritime states. So first of all, and first and foremost, make the necessary implementations of the MLC into national laws. And I stress about it. The second thing is the mandatory registration and monitoring of recruitment agencies. And what I mean in that is that seafarers usually go into recruiting agency to find them a place on board a ship. But however, these recruiting agencies, not all of them are collaborating with the Montenegrin government. So some of the seafarers can go on board without a collective bargaining agreement, or what is known as a collective employment contract. So it's going to be hard to follow each case of every seafarer. Thirdly, create a national seafarer registry with regular data updates. Thirdly, establish an emergency support mechanism for abandoned seafarers. And in this case, I would like to say that, like my colleague Maša is a MLC focal point, they suggest that this team gets bigger, so more support can be granted to seafarers, foster cooperation with neighboring maritime countries, enhance training for MLC experts and maritime inspectors so they know what to look for, and finally, develop and improve ship registry, following Malta's example, but develop and improve ship registry specifically to create new opportunities for these seafarers to sail under the Montenegrin flag. And finally, I would like to conclude with our seafarers. These are known faces. These are the seafarers that were on board the ships, we take their agreement before posting their photos here. And thank you for listening.